Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. If you've just subscribed to my YouTube channel, thank you for subscribing. It helps everyone. Let's talk about some things important today. This was a picture I posted on my Facebook page. I hope everyone had a happy Valentine's Day. And if you are in foreclosure, hopefully you are still in your house and not going through eviction. So today's topic is going to be important for both judicial and non-judicial. Let's get started. So today's topic is going to be on the foreclosure life cycle. And as you can see by this map, you'll see the difference between a judicial foreclosure process and a non-judicial foreclosure process. The red states are judicial foreclosure states, and you can see by the red, you can see that it's North Dakota, South Dakota, Wisconsin, Iowa, Illinois, Indiana, Ohio, Kentucky, Kansas, Oklahoma, New Mexico, Louisiana, Florida, South Carolina, Pennsylvania, New York, did I say Kentucky? Maine, Vermont, Connecticut, New Jersey, Delaware, the District of Columbia. So you can see all these are judicial foreclosure states. And so let's talk about the life cycle of a judicial foreclosure. Stage 1, default. Before the court ever gets involved, what happens? The borrower misses payments under the note. Loan goes into default per the contract. The servicer starts internal collection and loss mitigation. The key points on this is not a foreclosure yet. No court, no judge, no case number. Fees and default charges often start piling up here. The opportunity window is requests for information, and QWRs or qualified written requests are sent to the servicer. Early documentation, traps for the servicer. And again, if they screwed up on anything, you got them. This is a time period of about 1 to 6 months, give or take. Stage 2 is pre-foreclosure, notice phase. What happens? Notice of default, notice of intent to foreclose is sent. And it is, again, state specific, so you have to look up your state for all their foreclosure laws. The servicer claims the right to accelerate the loan. Referral to foreclosure counsel often occurs here. The key points are, this notice is usually a condition precedent. Defects here can later kill the case. Most borrowers still think nothing legal has happened. The opportunity window here is challenge standing before the lawsuit, demand proof of authority and chain of title. Loss mitigation violations often occur here, and you have a 1 to 3 month time window. Stage 3, filing the foreclosure complaint. The lawsuit begins. What happens? Plaintiff files foreclosure complaint in court, claims it owns the note and mortgage, requests judgment and sale of the property. The key points on this is civil litigation. The plaintiff bears the burden of proof, very important. Standing must exist at filing and not later. Your opportunity window is to file either a motion to dismiss, challenge standing, conditions precedent, defective assignments, and endorsements. Look for any defects in your chain of title and point them out. This is an event, not a duration. Stage 4, service of process. What happens? The borrower is served with a summons and complaint. The clock starts running, usually 20 to 30 days. Key points. This is where many people lose by default. If you don't answer it, it equals admissions. Courts assume facts are true if not denied. The opportunity window. File an answer, even a basic one. Assert affirmative defenses. Preserve your counterclaims. 2 to 8 weeks, sometimes longer. What slows it down? Bad addresses, evasive service, process server errors. No service equals no obligation to respond yet. Stage 5, answer defenses and counterclaims. What happens? The borrower responds to the complaint, raises defenses and possibly counterclaims. Key points. This defines the battlefield. What you don't raise here may be waived. Counterclaims can shift leverage dramatically. Opportunity window. Argue standing and authority challenges. This is where you have your FDCPA, RESPA, and state consumer claims against the servicer. Fraud, lack of consideration, void assignments. 20 to 30 days after service. This is where people accidentally shorten their own case by defaulting. In other words, don't ignore this. You got to respond to it. Next is stage 6, the discovery phase. What happens? Parties exchange evidence. Requests for production, admissions, and interrogatories. Key points. This is where foreclosure cases are actually won. Servicers hate producing originals and witnesses. There's inconsistencies start surfacing here. The opportunity window, when you go after chain of title, payment histories, boarding records, authority of signers and servicers, 1 to 3 months. Motions to dismiss, motions to strike, court scheduling lag, even weak motions will buy you time. Stage 7, dispositive motions, usually summary judgment. What happens? Plaintiff files a motion for summary judgment, claims no genuine issue of material fact. Key points. This is often the lender's real goal. Many cases end here correctly or incorrectly. Judges rely heavily on the written record. Opportunity window. Expose factual disputes. Attack affidavits and business records. Show standing defects that cannot be cured. 3 to 9 months, often longer. What stretches this is incomplete responses, discovery disputes, and court congestion. This is the longest and most powerful phase. Stage 8, judgment of foreclosure. What happens? The judge enters judgment. Amount owed is fixed, often inflated. Sale is authorized. The key points here is not always the end. Judgment can be vacated, appealed, or stayed. Errors here matter a lot. 2 to 6 months, guys. Motion filed, opposition deadline, hearing scheduled, ruling issued, or is often delayed. The reality here is judges rarely rule immediately. Supplemental briefing is common. Stage 9, sheriff's sale, foreclosure sale. What happens? Property is auctioned. Plaintiff often credit bids. Title transfers process begins. The key points here is a sale does not equal an eviction. Sale can sometimes be undone. Confirmation rules vary by state. Event, but effects take time. Stage 10, post-sale and eviction. What happens? The deed is issued. Possession proceedings begin, and appeals or post-judgment motions may still be pending. Key points. Foreclosure court does not equal eviction court. Ownership and possession are separate issues. Title defects can surface after the sale. What delays the sales? Bankruptcy filings, motions to stay, and plaintiff unpreparedness. Stage 11, confirmation of sale, issuance of deed. What happens? The court confirms that the sheriff's sale, if required, some states do, sheriff's deed or commissioner's deed is issued. Title is transferred to the purchaser, often the bank. Key points. Ownership changes here, not at judgment. This does not give possession. The occupant is not yet a trespasser. Important distinction is ownership does not equal possession. And there's about 2 to 8 weeks for this stage. Stage 12, demand for possession, notice to vacate. What happens? The new owner sends a demand for possession, gives a deadline to leave voluntarily, and again it varies by state. Key points. This is usually not a court order. It's a prerequisite step before eviction. Many people panic and leave here unnecessarily. The opportunity window is to challenge the title defects, raise pending appeals or motions, and negotiate cash for keys. The time frame for this is 1 to 4 weeks. Stage 13, separate eviction, possession action. What happens? The purchaser files a new case for possession, often called eviction, ejectment, or unlawful detainer. Different court in many states, different legal standards, depending on what your state is. Key points. Foreclosure court is usually done. Eviction cannot decide title. If possession depends on unresolved ownership, eviction can fail. This is huge. Many post-foreclosure evictions are legally defective because title or authority is still disputed. Again, the time frame is 1 to 3 months. Stage 14, judgment for possession. What happens? The court grants possession to the purchaser. Deadline to vacate is set, often short. Key points, still not physical removal yet. Appeals or stays may still apply, and tenant protection laws may extend timelines. Now, stage 15 is the writ of execution, writ of possession. What happens? The court issues a writ. Authorize the sheriff or constable to act. This is the first time force is legally allowed. The key points in this is a court order. Without a writ, law enforcement cannot remove anyone. The writ defines the sheriff's authority, and the time frame is 1 to 3 weeks. Stage 16, sheriff lockout, physical eviction, and this again is the end point. What happens? The sheriff posts or executes the writ. Occupants are physically removed. Locks may be changed, and property is turned over to the purchaser. This is the moment. This is the first point where the person must leave the property. Everything before this is paper, procedure, and process. Foreclosure takes your ownership. Eviction takes your possession. Only a writ executed by a sheriff forces you out. Okay, so total time, judicial foreclosure, realistic range, from the first missed payment to the lockout. First case, 12 to 15 months, fast case, 12 to 15 months. Average case is 18 to 30 months, and contested cases is 30 months or more. Now, the highest time impact, months, years, these actions force court involvement and slow everything. These are things you can do, guys. Filing a timely answer with defenses prevents default judgment, forces plaintiff to prove its case, opens discovery, adds another 6 to 18 months. Aggressive proper discovery, requests for production, requests for admission, and interrogatories can add 6 to 12 more months. Banks can't move fast when they have to produce evidence. Motions to compel discovery. Exposes evasive responses, forces hearings, creates a court backlog. It can add 3 to 9 months. Summary judgment opposition requires briefing and rulings, often triggers supplemental filings, adds 3 to 6 months. Now, medium impact, as far as adding more time, these actions slow the case but doesn't stop it alone. Motions to dismiss, procedural, or standing based. Even when denied, they delay scheduling. It'll add 1 to 3 months. Amended pleadings or counterclaims resets response deadlines, sometimes restarts discovery, and adds 1 to 4 extra months. Court congestion and continuances. Judges' calendars matter. Plaintiff unpreparedness helps defendants, adds 1 to 3 months, often more. These actions that lose time, let's talk about that. These move speed foreclosure up, ignoring service, missing deadlines, filing incoherent or irrelevant pleadings, attacking judges or opposing counsel, waiting until the sale date to act. Silence is the fastest foreclosure strategy for the bank. Okay, guys, I hope this has been informational for a lot of y'all going through foreclosure if you're in a judicial state. I will do a next presentation on non-judicial states if you're wondering. And if you have questions, leave them in the comment section or send me an email. My email address is foreclosurehelp777@gmail.com. As you can see right here, it's spelled like this. You can join my private Facebook group, and I hope everyone has a blessed day.